Thank you. Thank you very much. Uh, Perhaps I should say a bit more about my background before I go through my statement. And I'm just going to highlight aspects of the statement. I assume that people have already read that. Uh, I graduated from Yale Law School, where I served as an editor of the Yale Law Journal. Upon graduating from law school, I clerked for a federal judge, and then I worked for a time as a corporate lawyer on Wall Street at the firm of Cravath, Swaine and Moore before becoming a law professor at the University of San Diego Law School. And I'm in my 43rd year of teaching, both at the University of San Diego and at another school, actually two other schools. And during that time, I produced, with the help of some very capable students, over 20 books and 100 articles. The last 25 years, I've been focusing on past atrocities and post-conflict justice, writing a few books and several articles on that. Uh, and I got into the study of past atrocities, of redress, and I do refer to it as redress rather than reparations, because reparations is just one way of responding to a past atrocity, one way of effectuating post-conflict justice. There are others, and I talk about that in my statement. An editor of an academic press asked me if I would look at the matter of reparations. This was in the mid 1990s. And I rejected that because I thought that the notion was rather foolish, and that there was really nothing to be gained from spending time and effort on that. But but then he proposed that I look at it from an international perspective, which I did, and spent a great deal of time and a number of years traveling the globe basically, and presenting papers and studying with study groups around the world, in Poland, in Hagen, and I saw there, looking at the various ways in which governments responded to their past atrocities, that there were some best practices. And one of the practices is the one that I prefer, which is the atonement model. But before I get into that, what I'd like to do is to just sort of go through and to highlight various components of the international redress movement. I think that there are conceptual tools there, as well as experiences, which can greatly help us think through this complicated question of redress in slavery. Um, there are two basic methods, and understand we're talking about civil redress, not criminal redress. There are two basic ways of pursuing civil redress. One is what I term the tort model, the other is the atonement model. The tort model is backward looking, it is victim focused, and it is compensatory. That is to say, its main purpose is to seek compensatory justice and sometimes punitive justice. And that is sort of the received tradition. It certainly was a received tradition when I came on the scene in the mid 1990s. The competing model, which I saw in international experiences, is the atonement model. And that model, in contrast to the tort model, is forward looking, it is perpetrator focused, and it is restorative. In other words, its primary mission is to seek restorative justice. And restorative justice means restoring a broken relationship between the victims and the perpetrator of an atrocity, and also to give the perpetrator of an atrocity the opportunity to restore its moral character in the aftermath of the atrocity. And the atonement model has two components. One is atonement, and the other is forgiveness. Atonement is the perpetrator side of the equation, and that requires the perpetrator to issue a genuine apology, and there are various ways of defining that term, which I can do, and which I do in the statement. I'd be happy to elaborate on that. And also to make the apology believable by doing a redemptive act. And that redemptive act is a reparation. So the concept of reparation under the atonement model is quite different from the concept of reparation under the tort model. Under the atonement model, the purpose of the reparation is to make the apology believable, to concretize the apology. And so the sincerity of the apology is calculated by the weight of the reparations. And I think that's quite important. And once a sufficient atonement, that is to say, apology plus reparations, has been tendered by the perpetrator, then the question of forgiveness arrives on the victim's desk, kind of like a subpoena, a civic one, not a moral one, because there's no moral obligation attached to the victims here. It attaches to the perpetrator. And the question of how does one manifest forgiveness, or whether one should, that is a question that the victims have to determine. I do not get into that in my statement because I was asked to focus basically on the perpetrator. So you have the atonement model and versus the tort model. Then there are reparations. There are various types of reparations. There are compensatory reparations, which are reparations that go to the victim or the victim's family. These can be cash or non-cash reparations. And then there are rehabilitative reparations, and these are cash or non-cash reparations that go to the victim's community. They're designed to rebuild the community in the aftermath of the atrocity. They are asset building reparations. They're quite different from the compensatory reparations. Now, I prefer, as I said, the atonement model, not because it's something that I sort of came up with, but I think it is superior to the tort model. And that can be seen with the following example. Let us suppose that you are standing on the street and some stranger or someone even that you know walks by and steps on your foot and looks back at you and keeps going, doesn't apologize. How insulting is that? And it seems to me that redress ought to be about the dignity that has been visited upon the victims. It ought to be about a reconciliation, making this society better, making our state better. It ought to be about elevating our humanity as a people. So that is why I prefer the atonement model to the tort model. In terms of reparations, I am not in favor of compensatory reparations because they are so complicated. So, for example, most reparations, compensatory reparations, are direct cash payments. Well, the individual can take that and gamble, go to Las Vegas to gamble it away, and that gives evidence to Chris Rock's famous quip that the only one who is going to benefit from reparations is Kentucky Fried Chicken. And I can tell you the experience in South Africa, talking with the attorneys there and working with the attorneys there on the Truth and Reconciliation Commission, which I did, and also talking with attorneys who have represented victims there and speaking with them at international conferences. And they tell me that after 1 year, the victims are poor again. The solution to that, some would say, well, let's have conditional cash payments, meaning that you can only use the money for certain purposes. that is morally reprehensible in the view of many individuals, including myself, because you're denying agency to the victims. And we don't do that with anyone else who receives a compensation from an injury. So the other problem with compensatory reparations is that they are very, very difficult to formulate, difficult to administer, and difficult to determine who gets them and who does not. For all of those reasons, I do propose and recommend strongly rehabilitative reparations, but I do not suggest that you provide a hodgepodge of rehabilitative reparations. In other words, you should focus on one or two important items. And in the paper, my statement, I recommend boarding schools as a focus. And why? Well, because boarding schools are foundational. Once you get a good education, it opens up all kinds of opportunities. There are socioeconomic benefits that derive from that. I look at the African American students who were my classmates at Yale Law School, including one Clarence Thomas, and all of them have done well economically, socioeconomically, and more importantly, their children and grandchildren have done well. They've gone to very good schools and they've gotten very good jobs, and I think that that's foundational. The other reason why I would focus on boarding schools and education in general and is because what we've learned from Thurgood Marshall and the Legal Defense Fund is that focusing on education is a very good way to attack racial injustice. It's sort of a leader in the vanguard of the attack because it's very hard to argue against education, quality education. So for these reasons, I do recommend boarding schools that would be located throughout the state of California in green belts. That is to say, not in the city, but outside of the cities. And one thing to understand about education is that education takes place less in the classroom than at home doing homework. That's where it takes place. And my daughter, who attended Princeton, the Princeton had the system where they would have tutors available at 12 midnight at 2 in the morning for students. And that is the sort of thing that I think a boarding school could do. It would be a total environment which would be conducive to a quality education. And with that, I think my time is up. Thank you.